Thanks for joining in on another one of our webinars. For those that have played before, can I just get you to raise your hand, press a button that looks like a hand on your control panel, just to make sure that you can hear us. Terrific, it looks like a few hands are going up, so I'll take that as confirmation that you can hear me. Thanks for joining us to talk today about some of the ethical issues or challenges that can come up in multidisciplinary legal practice. My name is James, I'm from Quails, and I'll make a couple of introductory comments before I hand over to our presenters. Can I begin by acknowledging the traditional owners of the lands on which we're digitally gathered. So we're here in Brisbane, and so I acknowledge the Turrbal and the Yagara people as the traditional custodians of the lands around Brisbane. But there are people joining us from across Queensland and indeed across Australia, so we acknowledge first Australians across the country and pay our respects to their elders, past and present, and emerging leaders. For those that haven't used this technology before, I'll just go through a couple of housekeeping type things and then hand over to the expert content that we're going to hear, which is particularly important in community legal centre practice. So there are a couple of ways that you can ask questions as the presentation goes on. You can press that button that looks like a hand on your control panel. We'll see your hand go up at our end. We'll be able to unmute your microphone, and then you can ask a question using your microphone, whether you're listening to us or speaking to us through your computer or through a phone. The other way that you can ask a question is to type a question into the questions box. We'll see that pop up here and we'll read it out or paraphrase it and respond to it that way. Webinars aren't great for kind of conversational teaching, and so if you could hold your questions until the end, that'd be ideal. If you have something urgent though, feel free to raise a hand or enter a question into the questions box. A PDF copy of Warren and Amanda's presentation is accessible through the control panel, and I'll turn that off. And we'll also email around a copy of that, and if the technology works for us, we'll also send around a copy of the recording of the presentation as well. That's the housekeeping-ish type things. So without any further ado, I might hand over to Warren Strange and Amanda Whelan from No More, the legal service for people engaging in the Royal Commission into institutional responses to child sex abuse. They can talk a bit more about the organisation and its work and their respective roles there before maybe going into this really important issue of us understanding our professional responsibilities and obligations when lawyers and social workers are working together. So over to you guys.
Thanks, James. Good afternoon, everyone. We're very pleased to have the opportunity to speak to you this afternoon. Amanda and I would like to begin with by also acknowledging the traditional owners of all of the lands upon which we're gathered today, and as James said, we've got people from around Queensland and New South Wales as well, and Victoria, I think, so we acknowledge the traditional owners and pay our respects to their elders. By way of quick introductions, my name's Warren Strange. I've been with the No More Legal Service since pretty much the beginning, around May 2013. I started originally in the role of principal lawyer with No More, and last year I became the executive officer, which is in effect the CEO position. I might just ask Amanda to introduce herself now too.
Yes, hello everyone. My name is Amanda Whelan. I'm the team leader of the support services team at No More. I'm a social worker by qualification. I've been working in the former area, I guess, for about 19 years, and I came to No More in January of last year after working at Lotus Place with Forgotten Australians and former child migrants. Thank you.
Thanks, Amanda. Today in the webinar we wanted to talk, obviously the title of the presentation is around ethical issues. I think we've used the words ethical dilemmas, but it's probably a better term to talk about issues, because I think what we've found in practice is that some of the problems and difficulties that we envisaged when we were establishing the service to operate as a true multidisciplinary model in effect have not really been great problems in practice, and the advantages that we've found of having a blend of different disciplines working together have far outweighed some of the potential ethical issues or challenges that we found when we were building the service. So we wanted today, our aims are to try and share with you some of the insights and learnings, lessons that we've learned from our experience of using different professions and disciplines to deliver services to our client group, and to talk about some particular ethical issues that loom very large in our day-to-day practice, such as effectively communicating with clients and discharging the obligation we have as lawyers in that regard. Capacity issues come up for us quite frequently, and then finally scenarios where you may need to contemplate breaching your client's confidentiality because of the fact that they've made threats either to harm themselves or to perhaps harm somebody else, and how we approach that, particularly in a multidisciplinary way, utilising lawyers and social workers and counsellors. We'll have some time at the end of the presentation to take questions, and in the PowerPoint we'll also provide you with details of how to contact us if there's anything you'd like to follow up. I wanted to talk first about the context because our service operates as a community legal service in each state where we have an office and where we practice, but we are unique in that we were established in response to a specific external event, which is the Royal Commission into Institutional Responses to Child Sexual Abuse, and we've been set up for that purpose and for a limited time, in that respect we're different to most other services. So in understanding the context of how we operate, going back to the Royal Commission's terms of reference, which we've got on the slide there now, those terms of reference are quite extensive, but a significant part of what was envisaged when the Royal Commission was established was for it to have a function of bearing witness to the experiences of people, and there's a specific term of reference there that the Royal Commissioners have obliged by the letters patent to have regard to the experience of people directly or indirectly affected by child sexual abuse, and also to look at the provision of opportunities for them to share their experiences in appropriate ways, while recognising that many of them will be severely traumatised or will have special support needs. So this Royal Commission is quite unique in that it has a statutory power to hold private sessions which involve generally a survivor of child sexual abuse meeting with one of the commissioners and a commission staff member in a fairly informal environment, and having the opportunity to speak openly and confidentially about their experience of child sexual abuse. Last week the Royal Commission made an announcement about these private sessions, and to date they've held over 5,000 of them around capital cities and major regional centres around the country, where people have come forward to talk about their experiences, what happened to them, what they would like to see happen in the future to lessen the risk of recurrence of child sexual abuse, and also what they personally need now by way of justice for the experiences that they've been through. Just wanted to note quickly that that announcement last week by the Royal Commission was about the closing date for registrations for these private sessions. At the moment, if you contacted the Royal Commission and registered, there would be a delay of between 9 to 12 months of when you would actually have a private session and that opportunity to meet. So the Royal Commission is due to report by the end of next year and won't be going past that time. So it needed to set a cut-off date for taking new registrations, bearing in mind there's likely to be a rush towards the end of that period. So if you are speaking to any clients who potentially might be eligible or might be interested in having a private session, then they must register now by the 30th of September. So that's an important message to get out to all people who are doing advice with members of the public who, if you're asked any questions about that, then that is now the closing date and there won't be any exceptions. So if people don't register by that time, they won't have that opportunity, and we're not sure what might follow the Royal Commission by way of those sorts of opportunities to have some official bear witness to their experiences. Very quickly, following on from those terms of reference, the process of establishing the Royal Commission involved consultation with a number of key agencies around the country, which included the CLC sector, and the National Association, as the national peak body, put together a submission for the Australian Government talking about the legal needs of survivors if the Royal Commission did intend to engage with them and to have them participate in its processes. Then NACLAC was very keen to ensure that based on the experience of CLCs in delivering services to vulnerable people, that appropriate legal assistance was in place. Government responded to that by asking NACLAC to establish and auspice a service, and that has become the No More Legal service. Our funding agreement again recognises that we are to provide specific services, and I've listed those there in the slide. There's a couple of points to note. One is that we are primarily a national telephone service with people being able to contact us through a 1-800 number. That's our primary first option method of service delivery. Secondly, it was always envisaged in the funding agreement that we would provide counselling services and that they would facilitate and support clients obtaining legal assistance. The funding agreement also made some provisions around what our staffing model should be and effectively mandated a tripartite model of service delivery of lawyers, specialist staff for Aboriginal and Torres Strait Islander clients, and specialist staff trained and experienced in dealing with victims of sexual assault and or trauma. In reality, all the roles in our service we have recruited. We've tried to look for people who've had some background in assisting survivors of sexual assault and trauma, whether they're lawyers or whatever role they're employed in. So it was always envisaged that we would have a multidisciplinary model. To date, we've assisted over 4,500 clients, and the majority of those are survivors of child sexual abuse themselves. That's their experience, and that's the perspective that they're bringing when they're in contact with us to seek legal assistance. Around 20% of those clients have identified as Aboriginal or Torres Strait Islanders, and we've had a very specific program of trying to engage with Indigenous people in recognition of the many barriers that they've always faced in engaging with legal services and ensuring that they receive proper legal assistance. The way our practice is structured, we have 4 offices, Brisbane, Sydney, Perth and Melbourne, and we visit the other states and territories where we don't have a regular presence. Each office is managed by a position, a senior lawyer role, which we call the managing lawyer, who is the manager of that office. We have a principal lawyer who sits above the managing lawyers. Managing lawyer has direct supervision of all staff in the office, and that includes social workers and engagement advisors. But we also have discipline team leaders for the social work support team. Amanda holds that role, and we also have a Aboriginal and Torres Strait Islander engagement team leader as well. So they are the team leaders for discipline issues, but not the day-to-day managers. I might hand over to Amanda now to talk a little bit about our service model and what follows from that context of what we were established to do.
Thanks, Warren. I think when we think about Know More and the way that we approach working with our clients, that it's really grounded in some key things. One of them is of huge importance is about being trauma informed. So we have worked closely from the materials and support of ASCA, which I now believe is called Blue Knot. And that's because they are, I guess, the practice leaders in terms of practice standards around being a trauma-informed service. So that's one part of what we do that's really important. And it's important in saying that it threads through all layers of the service. It's not just something that we that just comes from the social work team, for example. Person-centred is really important. It's about saying that the person is at the forefront and the centre of all the decisions that are made and all of the ways that we wrap around how we work. We also within that need to acknowledge that for some of the people we support, and I know that I also want to say that everyone in the CLC sector I'm sure works with a lot of the same clients or the same vulnerabilities, just perhaps in a different way. But that we also know that, at times people don't always make decisions that we might necessarily think are in their best interest, but they have a right to make them even when they're poor ones. So that's, some of where we come from, I guess, as well around it is very much driven by the person. The culturally secure practice framework is absolutely vital and it underpins everything that we do. I just want to also really acknowledge our engagement advisors and the absolutely invaluable work that they bring to Know More. I think that it really needs to be stressed again that a lot of the way that Know More's model was developed was out of the key learnings of the CLC sector and understanding that we were going to be working with incredibly vulnerable people. And as Warren's already outlined, that there was a decision made, I think a very wise one, to implement a multidisciplinary model. I know from being at the NACLIC conference last year, I met some amazing people who in their CLC areas are, have implemented that to the best that they can with their resourcing, and I think we've been extremely fortunate in Know More to have been resourced to implement such a strong multidisciplinary approach. And hopefully there'll be learnings out of that about what people need going forward. In saying that, some of the significant challenges that were identified at the start of the service, and I guess have continued to some extent, are that it's a national service. As Warren said, we're on the phone most of the time. You're talking about multiple jurisdictions. Majority of our clients have suffered complex trauma, so the impact of that is profound across so many different areas of their life. I'm sure I'm not saying anything to you that you don't know, but just that sometimes, their issues are significant, and we need to be mindful of that when we're working with them. That there might be disclosures of an intent to harm self or others, and then that would then trigger mandatory reporting or confidentiality breach obligations, I guess, for us as a service. That we also needed to be mindful that some people may have either offended in an institutional setting or may have other legal issues now as adults which they may require additional advice around. And that's not to say that excludes them from a service, it's just to say it's a potential legal issue that people need good assistance to think about their options before they come forward. There's also a group of people who, when their abuse has occurred in an institutional setting, they are understandably extremely mistrustful of institutions, of which Know More represents another one. Support services staying engaged and linked to services is often highly challenging for them. And in that, the types of support services that Know More provides are not ongoing. They are short-term approaches designed to link people to service. So they were some of, I guess, the challenges that we identified early on. I'm going to hand back to Warren.
Thanks, Amanda. Just a couple of observations there from my perspective, being a trauma-informed service, the principle of client choice has always been at the forefront of our service philosophy, and we have no agenda around clients engaging with the Royal Commission. We realise that that decision is one for each client to make, whether they engage and what other options they might want to take, such as complaints to police or pursuit of a redress claim or a civil claim even, victims' comp claims, those sorts of things. So our aim is simply to give clients the relevant information and to enable them to make an informed choice. And as Amanda said, that is a choice that may not always be strictly in accordance with their legal interests. We have known clients at times who simply have not been able to pursue what would be worthwhile and probably successful redress claims, and they've chosen not to do that because of the impact of engaging that would have on their mental health and their physical health, and we've needed to give them information about their options but to respect that decision. I wanted to talk now briefly about the ethical framework. The lawyers who are listening will be familiar with these rules and the framework. The excerpts that follow in the next 3 or 4 slides are based on the Australian Solicitors Conduct Rules, which operate here in Queensland. New South Wales and Victoria now have the national uniform legislation and rules, but I think there's very minor differences between the various instruments there. So I think everything that I'm saying in the Queensland context is of application. Rule 7 is one of the fundamental rules, and it's a specific application of a solicitor's fundamental ethical duties, and it's stated there around providing clear and timely advice to assist a client to understand relevant legal issues and to make informed choices about action to be taken during the course of a matter. So it's a statement, an important statement of your duty as a lawyer to assist the client to understand those issues and to make an informed choice about their potential actions. Immediately following Rule 7, Rule 8 provides a solicitor is obliged to follow a client's lawful, proper and competent instructions, and competent here in our context clearly raises issues relating to the client's capacity. I'll talk a little bit more about that shortly. Obviously there's a presumption of capacity and different standards or different tests depending upon the particular legal exercise, but generally we're talking about whether the client can understand the nature of what they're doing and the legal consequences. And capacity is an issue obviously because of the complex trauma that the majority of our clients have suffered. Capacity looms large, and it often can be an issue that our clients will have capacity at times and not at others. Confidentiality, Rule 9 is the general rule there. That's an inherent part of the solicitor-client relationship which everyone would be familiar with, and the obligation to keep information confidential stems from the fiduciary nature of the relationship, also the retainer where one exists with the client, as well as the rules. And we'll talk about that in terms of exceptions, which I mentioned before, where clients are making threats about harming themselves or others. Rule 11 is another particularly relevant rule, and there are several rules relating to conflicts. Rule 11 is the one that governs avoidance of conflicts concerning current clients. So you shouldn't be acting, obviously, for 2 or more clients where their interests conflict, and that was a consideration for us in establishing the service. We knew that in looking at institutional childhood sexual abuse, many of the institutions where abuse occurred featured abuse by adults, but also featured abuse by older children upon younger children. That was often part of the environment. So we knew in setting up the service that we may have a significant number of potential clients falling within the terms of reference of the Royal Commission who might be at risk were they to make disclosures around their own offending. I'll ask Amanda now to talk about the ethical framework from the social work and counselling side.
Yeah, so no more employees, social workers and counsellors in the support services team. As Warren described before, that's a national team. We have 7 of us in total and we're based across the 4 offices. One of the things that I wanted to say about No More as well is that we will each of us operate within our office-based team, but then we'll also be part of our discipline team. So there's a lot of multi-team work as well that happens within No More, which I think really strengthens what we do. But from the support services perspective, the core role, I guess, of the team is to support clients to be able to give instructions to their lawyer and to understand the advice that's provided. Now that sounds simple. That's often, and it's also about supporting the lawyers to be able to work with people who sometimes have significant challenges and barriers in their life. Typically what that looks like is we would be asked in on a phone call that's usually instigated by the lawyer, but that is, you know, so that may be about crisis or sort of time and place support, I guess, and we do short-term support work. There's been a whole funded service system by the Department of Social Services around people engaging with the Royal Commission, so there are great services set up out there that do the ongoing work. So our role is not to take that on but to try to link people with those services. That being said, we also know that for this particular client cohort, sometimes, you know, that's not ever going to look like here's a number, just call them. So there's a lot of that work that we do to sort of encourage engagement. And we do a lot of networking with other services out there as well. The thing, I guess, that we come back to within our work as a support services team is that we're a legal service, we're working within a legal service capacity. So that's always, I guess, the guiding principle for us in thinking about where we would intervene and where we take our guidance from. And I think that's why the multidisciplinary model within a local office setting works really well to seek guidance as well from the managing lawyer. We do also have to be mindful of our own code of ethics and our other professional requirements. So the person-centred, trauma-informed, culturally secure model of No More aligns closely with the social work code of ethics. The social work values, I guess, that we've outlined there, anyone that's familiar with the code of ethics knows those. They are about respect for persons, about social justice and professional integrity. And there's also, under the NACLIC Risk Management Guide for CLCs, Mandatory Standards, the number 11, says that a centre worker or volunteer who is a qualified social worker and a member of the ASW must comply with the code set out by them. There's, I think, strong alignment with informed consent and confidentiality requirements across social work and legal practice. It is one thing we've had to think through is about mandatory reporting, also because we're national, so we're operating in different states and territories who all have differing legislation, as people would know, and differing interpretations of that legislation. In terms of our legal responsibilities, generally speaking, social workers employed by No More, we aren't mandatory reporters, but in the Northern Territory, for example, that there's legislation that mandates any person with reasonable grounds and excludes the operation of client legal privilege. So it's just something we have to always keep in mind whenever issues come up. That also, however, doesn't negate from ethical responsibilities. I've just put in there what the ASW's mandatory reporting ethical guidelines state, and you can read that in the detail, but I guess for me, I have found that that has been very consistent with how No More would approach any issues where there might be contemporary risk. in saying that, most of the people that we're supporting, I believe 80% of them are over the ages of 45, and so we're not engaging an awful lot with younger people or children where they might be at risk right now, but there may be occasions when we identify concern because of the adult that we might be working with, so that's what we have to consider, those issues.
One of the other issues which we haven't listed on a slide there, but it's worth mentioning, is because we're a national service, the potential relevance of sexual assault counselling privilege. In states and territories other than Queensland, there's legislation which prevents or restricts defendants in criminal proceedings from being able to obtain access to a victim's confidential counselling records, and there are circumstances which attract the operation or the potential operation of that privilege, and we wanted to structure our practice in a way that would preserve those sorts of obligations as well, and just be mindful of them. So in thinking about the establishment of the service and how the various disciplines would work together, we looked at a number of options, and it's important to note that underpinning the framework is a privacy and confidentiality policy, which is available there through our website. It's a joint ACLAC and No More one, and it makes specific provision for the operation of No More. This is a client group that we're dealing with, understandably so, I think, given their experiences, that are some of them are very conscious, very, very concerned about what use might be made of their information, to the extent that we have had clients express significant concern that their file might be transferred from one lawyer to another because of that inevitable sharing of information, and it's understandable given what they've experienced that is intensely private and personal information, and they want to know who might have access to it and for what purposes. So we've developed that policy. We also looked at the options for, I guess, intake of clients, and we had various options of counselling staff answering calls initially to that had a perceived advantage of being able to hopefully communicate with the client in a way that might ease some of their initial distress and apprehension. We looked at some of the typical intake models used in legal advice work. What we ended up doing was settling on a model where the lawyers will answer all initial calls from clients, and we went in that direction really to enable early decisions to be made about conflict, particularly where someone may be disclosing experiences both as a victim and as a perpetrator. We're dealing presently with a lot of clients who are in custody in prisons, so there's potentially other conflict issues there. It also lessens the retelling that clients might have to go through of their circumstances if they are able to recount enough information once to satisfy a lawyer that they are within the terms of reference of the Royal Commission. Advice can proceed from there rather than having to pass them on to somebody else for that same exercise. So that was the model we settled on. Our approach to engaging with clients around confidentiality, we realised very quickly that a scripted approach to advising clients doesn't work because of the different circumstances in which they present and different levels of stress and trust. So we do endeavour to engage with clients and explain our confidentiality obligations in that first conversation, but the precise timing of that, it mightn't be the first thing that we speak to a client about, depending upon their level of distress and what they want to talk about. So we will explain to them that across our organisation there may be somewhat differing obligations across staff and reporting obligations, and that our social workers may be under a different obligation to lawyers in that respect, and we'll seek their consent always in passing them to another staff member in those circumstances. We have found it helpful to talk to clients about the sorts of exceptions when we might, to stress confidentiality first of all, that in talking to us they are establishing a lawyer and client relationship, and we will respect the confidentiality, and then to talk very briefly and in more detail if the client wishes about the exceptions of when we may not be able to keep information confidential, such as if they make a threat to harm themselves that we take seriously. Moving on to client communication, all of you who work in the community legal sector will understand that communication with many clients can be challenging at times, that they present with vulnerabilities and linguistic issues, that English may not be their first language or their second or third language, clients with disabilities, clients who are under a great deal of stress and pressure. There's a case a little bit further on that I'll talk about, which talks about sophisticated clients, and I don't want to generalise unfairly, but many CLC clients and many of the clients that we're dealing with in our service, you would not call sophisticated clients in terms of understanding of their legal rights and their options, and they have very little previous experience, many of them, with the legal process or knowing what questions or what the issues are. So in those circumstances, the obligation to assist them to understand can be quite a heavy one. Any professional indemnity insurance seminar that you go to will talk about client communication issues as being one of the key causes of complaint and one of the highest category of notifications to insurers. It's worth noting, it's perhaps trite to note, but it's worth noting that Rule 7 doesn't make exceptions for busy lawyers or for lawyers working in CLCs or other environments. So it's a wide provision. To talk briefly about it, I mean, communication with clients is a large topic, and speaking today, I just wanted to note some particular things from our experience. One of the things to note from the language of Rule 7 is that it requires you to assist the client to understand what the issues are and what to make an informed decision. So there is an active obligation on the lawyer, requires you to actively participate with the client and to try and build some rapport to enhance that understanding. Clarity and agreement as to what you are doing is particularly important, and what is the scope of the work that you are doing for the client, a shared understanding of the purpose of the work and the scope and what you're going to be doing, and clearly understanding what the client is seeking as well. It's important, obviously, to communicate with each client in ways that they can understand, and always to try and look at things from their perspective. The obligation is on you to assist that client to understand their options. So again, the language of Rule 7 imports an obligation to look at things from the client's perspective. It's important always to be very mindful of the potential power imbalance between you as a lawyer or a CLC worker and the client. On this slide here, there are just some points that we've distilled from our practice. Again, as I said, this is a large topic, but some of the things that we've found always important to bear in mind is that how you effectively communicate depends on the circumstances and the client, and you need to find ways to be adaptive. That will change from client to client. It's a fine line between giving them too much detail to try and ensure that you're covering all the bases around the legal issues, but ensuring that you communicate in a way that they can understand. It starts with the environment in which you're speaking to the client, to put them at ease. We gave some thought to that in how we built our offices again with concern around privacy and confidentiality for clients that we are seeing personally or talking to over the telephone. Simple things like understanding that certain colours, red and black, are triggers for many of our clients as survivors of sexual abuse, and we've avoided those colour schemes where we can. How we dress. We know that black and white clothing for many survivors of clergy abuse is a clear trigger and can be a thing that will throw them and distress them significantly. One of the advantages, I think, of working in the multidisciplinary service is that we've been able, as lawyers, to enlist our colleagues to help with this communication, and certainly the role of the support team to help clients assist and understand the advice being given to them. The Aboriginal and Torres Strait Islander engagement team in building trust and safety and security with clients, as Amanda said, has been invaluable. We find with our client group that separating issues point by point and structuring things over a number of discussions is often the best. There's too much information. And many clients have not ever made a disclosure of sexual abuse before, and to talk to them about their own safety, to talk about this, to talk about the Royal Commission, talk about redress, that should be over a number of separate conversations rather than one long conversation, which can tire and distress clients and get them to a point where they're not engaging effectively. Always important to let the client know that they can ask questions. As I said, we make a point of explaining our confidentiality obligations to try and engender trust, but keep reminding clients that they can ask questions and seek information from you. And materials may assist. All sorts of strategies can assist in that regard. I know many CLCs use fact sheets and resources extensively. Any aid to having people understand, we're moving towards developing some graphics as fact sheets, getting away from the traditional legal word-heavy type of fact sheet. Last couple of things, it's important to try and confirm what your client's understanding is, and not simply by asking them, do they understand what you've just said, but finding ways to test that, getting them to demonstrate that they understand what you said and what options you put forward, that they can talk through the implications and that they can explain reasoning as to why they prefer a course of action. The last one will depend a little bit on what you're doing and your centre's policy, but usually helpful to confirm instructions and your position in writing. Okay, I wanted to talk very briefly about a case there, which I think is a useful one, and it was recently cited in a ethics presentation that I attended in New South Wales, so if it's at the forefront of Law Society thinking, it's probably worth sharing. It's a Victorian case, Berger, and without going into all the details, it's a decision of the Court of Appeal. Mrs. Berger was the central figure in the case. She was an elderly Polish woman, 82 years of age, who had no prior business experience and had never been involved in any business. Her late husband and her sons had run a business, and through a series of commercial structural decisions, it came to be that after her husband died, she was potentially available to act as the trustee of his estate. The problem was that the business had entered into a number of contracts and partnership arrangements, and the legal reality was that if she became the trustee and executrix of the estate, she would therefore become liable as a partner for the debts, and under the partnership laws she would be severally liable for all of those debts. And the case at first instance found that she was liable. That was appealed. She had sought that her lawyers indemnify her for the debts imposed upon her on the basis that they'd failed in their duty of care. The issue was whether they had a duty of care to advise her of the legal consequences of the acceptance of the office of executives and trustee, and that would potentially make her liable for the debts when she became a member of the partnership. And at the end of the day, the Court of Appeal found in her favour, noting that she was a client plainly lacking in sophistication, not knowing what specific advice to ask for, and on the face of things was reliant on her lawyers in relation to the pitfalls and legal obscurities. So that was a useful statement of what the lawyer's duty is there. Capacity, I don't want to say very much about, other than to note that it's a very important issue, and one could again have a further seminar just on the topic. A multidisciplinary model of services working together, we have found, is an important and very useful way to support a client's capacity and to increase their capacity. Capacity is something that, as I said, can come and go depending on the circumstances. It's specific with time, and we've found that many clients who present with elevated distress can be supported to a point where they can give appropriate instructions and have capacity to receive and act on advice. I've put a couple of references in the slide there to resources, and the QAI handbook, which was published last year, is a wonderful resource on capacity and all of the things you need to consider when you're dealing with clients there. Client communication, I'll just ask Amanda to talk briefly there about some of the lessons learned from our service and how we've structured things.
Yeah, I think just back to our initial comments really was that it's really been about working in a multidisciplinary way, and working person-centred. So we kind of weave around the person rather than have moved away from, I guess, just those sort of disciplinary silos of practice. And that it's really about ongoing education and knowledge sharing, so like talking to each other all the time, and not trying to do the other discipline's job. I'm not a lawyer's not a social worker, and so it's those kind of things really. Going to the next slide. We also, I think the other thing, and we don't have a lot of time to talk about this today, but the other thing that I think has really helped us to embed this is it kind of exists across all our layers. So there's no lead discipline when working with somebody. So it depends on the person and what they need. So a lot of the times it might be the engagement advisor, for example, who really leads along with the person about the work that we might do, or it might be the support team worker, it may be the lawyer, and that we also have a really great, that's reflected in our management team as well. So the way our organisation is structured, as Warren said before, we have discipline leaders who have a place within the management structure of No More. We have great opportunity for supervision, and that in part comes about wanting to support staff around, we want to make sure people aren't impacted by vicarious trauma and other things that happen with trauma work. That we have a strong supervision framework. People have team meetings, they have team supervision, they have individual supervision, we have employee assistance programs that are available. So there's lots of opportunity, I guess, for people to reflect on their work and on the impacts on them and how to work best with the people we support.
One example, I think, of how the structure works in practice, and the sort of flexibility that we've tried to bring to our service delivery, is that at the beginning we had a model of where lawyers would speak to clients and tell them about the availability of our support team and refer them on with the client's consent. That was in effect an opt-in model. We now have moved to an opt-out model where we'll tell them that unless they tell us otherwise, we will refer their matter to a social worker for follow-up to check on their well-being and to check in with them as their matter unfolds and ensure that they've got adequate supports. And most clients are embracing of that level of support. Just wanted to talk quickly about disclosures that might have to be made if clients make threats. We're running out of time and I want to leave a bit of time for questions, so I'll do this very quickly. It's worth noting the Queensland Law Society has some very good resources, some fact sheets around what to do in these sorts of circumstances. They're always difficult cases. We knew we would deal with them frequently. I think in 20 odd years of practice or more before I joined No More, I'd been involved in 2 disclosures under these exceptions. We've probably hit weeks where we've done more than 2 in the 1 week dealing with our current clients. So usually these things happen in circumstances of urgency and you don't have the luxury of being able to get external advice about your obligations, because if it is a serious and imminent threat that has you thinking about the likelihood of your client following through, then there is urgency. You don't have the luxury of reflecting at great length about things. Always look at what options there might be. Many of our clients, we look at whether the threat, particularly around self-harm, is something that we feel they are likely to follow through on, or is it more something that they're disclosing by way of frustration with how matters might have unfolded. And we have endeavour to engage with clients and have conversations to try and assess the likelihood of whether they intend to follow through, and that includes things around the access to the means to action their threat, those sorts of things. We found it invaluable to have obviously trained social workers and counsellors on staff to provide some expert guidance and insight into what how clients might be reacting. It's always useful to try and gather as much information as you can from your file or from colleagues who've had dealings with the client. And you may know that if somebody's making a threat, if they've got an extensive criminal history of violence, that might persuade you that the likelihood of them acting on the threat is perhaps higher than if you didn't, if you weren't aware of that sort of information. The only other thing I want to mention there is there's often no right answer. It's not an exception to the confidentiality rule that compels you to make a disclosure, but it does permit you to. And my advice would simply be to go with what your gut ultimately tells you in those circumstances after you've talked to your colleagues about it. Don't make the decision in isolation. Talk it through with senior people in your organisation, but at the end of the day, document what you've done and why, and that should protect people against any comeback in terms of an alleged breach of their confidentiality. They're not easy decisions and there's no right answers, but at the end of the day we are talking about people's welfare, and we've always disclosed to people when talking about confidentiality that we might be needing to make a report in these limited circumstances, so we put that on the record at the beginning. All right, we're very much approaching the end time, so thank you for all your attention. Very much appreciated by Amanda and I. We're happy to take any questions that might have come in, or alternatively the last slide on the PowerPoint has our contact details, phone numbers and email. Email's probably the best for contacting me, and we're happy to talk through any issues or questions that people might have.
Terrific. So it's James here again. I'll help with drive some of the questions and things. A reminder out there that there are a couple of ways you can ask questions. One is to press a button that looks like a hand. We'll see your hand go up here. We'll unmute your microphone and you can ask a question. The other is to type a question into the questions box. So while people are preparing their questions, can I just ask, and I think you touched on it in a couple of places, one slide in particular towards the end, Amanda, sometimes there's feedback in multidisciplinary practices that one profession is, I don't know how to say this, maybe valued more highly than others in a particular organisation. So I'm interested in the structural or the cultural things that you've done at No More to make sure that there's a real respect across and between the different disciplines, and it's not seen as a legal service with kind of social workers or actually engagement advisors kind of bolted onto it.
Yeah. I think for me that it starts with the model, honestly. It starts with that there is recognition for the disciplines that are management. Like it's in the structure, and I think that greatly assists. I think the creation of the team leader positions as well, and having a say there. I honestly think a lot of it comes from the day-to-day ways that the managing lawyers run their offices too. You know, each of the teams have a really great multidisciplinary culture, but that's not easily cultivated, and it does take, it takes investment. And I also think it's about, we have opportunity for multidisciplinary discussion, so there's supervision and things like that as well. We can kind of hash it out in a safer place, I guess. I think as well, maybe it's because of the nature of who we're working with, that there is a recognition that that we couldn't really do it as effectively without the three disciplines. But yeah, I mean, it's not always easy. I think, and there's probably been times when we've struggled here and there. But I genuinely do think like No More's come to it wanting to have that recognition there, and I think that's a big part of it. It's not lip service. Yeah.
We have tried to embed that in the culture, James, and I do speak to all new staff, and I use the words that lawyers are not the preeminent beings in the organisation. We do have the support team, the engagement team on the management team. They all contribute to policy submissions to the Royal Commission and other agencies, those sorts of practical examples to recognise their expertise and their authority. But as Amanda says, I think some of the challenging client interactions that we've all gone through, when I was doing client work at the beginning, put you in a position where you are so appreciative of the cultural guidance of an engagement advisor or the expertise of a counsellor to help you deal with that client. It becomes a reinforcing model in that respect, but it's not about bolting them onto the side and having isolated roles.
Thank you. A reminder again, guys, excuse me, you can ask questions by typing a question into the questions box, or you can press a button that looks like a hand on your control panel. One of the questions that has come through, excuse me, and I'll read it out and get your feedback, maybe starting with you, Warren. How do you deal with the issue of a possible breach of legal professional privilege when social workers and lawyers see clients together? So that question of privilege, and when is privilege waged, when some of your team from other disciplines are in the room, or when there are other support people in the room?
That was part of our thinking of having phone calls answered initially by a lawyer, particularly to sort out early identification of any conflict issues or any legal issues that might expose a client through their disclosure. We then operate on a principle of informed consent for them to talk with other support workers. We do take the view that legal professional privilege will apply if they are assisting the lawyer for the purpose of that client getting legal assistance, to get advice and to give instructions. So they are employees of the legal service. For us, it can be a little bit greyer where the counsellors are in a more traditional counselling role, and that might be circumstances where they might be providing crisis support to one of our clients, really not in relation to a legal issue or an issue at the forefront of the services that No More's delivering. We have many clients who will present in crisis because of something else that's happened in their life, and we do always try and engage with clients early on to explain that there may be some differing obligations there if there are disclosures. But having lawyers initially talk to the majority of clients will help filter out any issues and help make informed decisions around the best way to go to protect that client's interests.
And it's not infrequent for the lawyers before you are brought in on a discussion. We agree on what's relevant to why I might be getting involved, and you'll get a sense that there's a legal issue of some kind that it's probably not relevant for me to discuss with the person or hear about. But then sometimes people blurt it out anyway.
And that's always a risk. So
yeah.
Which is too late to try and put things back in the box after that's been said.
Can I ask on a kind of related point then, my understanding of the service, and it might be misguided, is where you're referring to an external support service, where possible, you'll make a fairly detailed referral as part of the trauma-informed service so a client need not repeat their story. And I wonder about the ethical implications or the professional responsibility implications that come from, you know, writing that letter of referral, disclosing information that's been disclosed to you in the context of providing legal advice, and how you manage that tension.
Yeah. Again, it's a client-by-client approach of we provide a lot of referral services, and I guess the depth of those referral services are guided by the level of client need. In essence, the more vulnerable and disadvantaged the client, the more assistance we will try and provide to make that referral successful so that it doesn't fall over. For other clients, simply identification of a potential redress claim, and we might provide them with some options for a law firm, and they'll be able to make that connection themselves. And with clients, we always look very carefully at what information is going to be disclosed and who we're making that referral to and for what purpose. And we'll seek the client's instructions and obtain an authority around disclosure of that information to a third party. Privilege will attach generally to the lawyer-to-lawyer disclosures, but if we're referring a person to a funded support service, for instance, that will be for counselling and support needs, and that will be the focus of the referral and the information.
Generally speaking, we haven't found a great need to get into an awful lot of detail, particularly about the person's legal matter. For me, I would always negotiate that with the person before I refer them about what I'm likely to say. Are they comfortable with me to share whatever? And it's really just about, most of the time, if you say you're working with someone because they're participating in the Royal Commission process, it's usually all you need to say in terms of that's a given then that they've had particular childhood experiences. So it's really about then more about how is that impacting on them now, what do they need, and the only other thing that's often really relevant to qualify and clarify is who's going to do what moving forward. So we're working on these particular legal matters or providing this level of support. What are you going to work on so that we're not all trying to do the same thing?
Terrific. I might just take one more question and again read it out. How have you navigated through situations, and I suspect the answer is it depends on the circumstances, but how have you navigated through situations where there's been a difference in approach to a client? For example, if the social worker is proposing a course of action in the best interest of a client, but the lawyer has instructions not to pursue that, how have you resolved those situations?
That has come up in practice quite, well, certainly not infrequently, across disciplines, across all disciplines really. There may be a difference of views, and again we've tried to approach that through the organisational culture of ensuring that we can have a robust discussion around that, and that if necessary we can look at getting senior people involved. We have Amanda in the role of discipline leader for the support team, so we have those internal sources of expertise that we can go to look at what's the appropriate response, and that will depend on client by client and issue by issue. But I think the important thing is to have trust, to be able to have a robust discussion around what the best interests and what the issues for the client are, and be prepared again within the client-centred model to put the client at the forefront of that, and perhaps park professional egos and those sorts of factors from getting involved in the decision. So we've worked at it, and I think that's an issue that will always come up in any type of multidisciplinary approach. But if there's an appropriate level of respect for each profession and leadership that models that and builds it in day by day, then I think you can overcome those difficulties.
At the end of the day, within the office context, it's usually the managing lawyer who makes makes the call. That being said, it's with input from everybody, and that works well, like Warren said, from a creating culture level. But as I said before, we aren't it's not a human service as such. It's a legal service. We're working with human beings. But, and that's been a thing that I guess, like I certainly hadn't worked in a legal setting as a social worker before, so it's something you've got to really adapt to. But it's about also like finding a place to make sure that your voice is heard, like we're there also to advocate for clients. But generally speaking, I think maybe again it's the nature of how NOMOR was established and why we exist, but talking about someone and their well-being is pretty much front and centre of all conversations, so maybe we're fortunate in that way.
We have had discussions with counsellors outside NOMOR who have espoused a view that no client should engage with the Royal Commission because that disclosure is going to be detrimental. Our view is, as I said at the beginning, we will give clients information about the options and let them make an informed choice. But that's an extreme example of where there might be differing views around the best approach.
We have got a few minutes over time, but I think that's fair enough because this is an important practice issue for community legal sectors, and drawing on the expertise and experience of Warren and Amanda and the NOMOR model and the NOMOR service and the fantastic work that we're doing, I think has been really helpful. Can I, on behalf of people who are clapping and cheering wildly at their desks around Australia, thank Warren and Amanda for a very thoughtful presentation and one that is really relevant to us working in community legal centres. We'll send around a follow-up email with contact details for Warren and Amanda if you'd like to follow up on any of the things that were raised today, and a couple of other resources.
Can I just say, I would love to hear from anyone, and if there's social workers out there, hello, and yeah, really loved being at an ACLET conference last year and connecting with people. I think our sector is amazing actually, and yeah, any and all questions welcome.
Terrific. So you're amazing out there. Thank you very much for getting involved in this webinar. Hope to speak to you in another one soon. Thanks and good afternoon.
Thanks.